Yes, Judge.
Okay. Let's go on the record on cause number DC 22-10595. Laura J. Cantu versus Kyle Smith. Counsel, make your appearances.
Tracy Dunlop, Your Honor, on behalf of plaintiff Laura Cantu.
Michelle Smith-Peters on behalf of plaintiff Laura Cantu.
All right, let's proceed.
And Your Honor, if I may introduce myself, I'm Stephanie Gaston on behalf of defendant Holy Savior Hospice and Jordan Smith.
Okay, you may proceed.
Your Honor, we have two motions on the court's docket today. We have a motion to compel Rule 194 required disclosures filed by Laura Cantu, and defendant's motion to quash plaintiff's notice of oral deposition. I'll be taking lead on the Rule 194 required disclosures, and Mr. Dunlop will be taking lead on the motion to quash.
Okay.
Your Honor, we tendered, well, under the new rules, this is a new rules case, required disclosures are due 30 days after the respondent makes an initial appearance. We tendered our required disclosures to Ms. Gaston. We did not receive any from Ms. Gaston on behalf of the two clients she represents. I did send an email to Ms. Gaston on approximately March 23, inquiring about the Rule 194 required disclosures. Ms. Gaston did respond and asked for additional time, and asked for the additional time to be April 3rd of 2023. And as you can see, Your Honor, we did deliver a trial notebook to the court. Hopefully that was given to you. And our exhibits are in that trial notebook, and under tab 1 is our first email correspondence between myself and Ms. Gaston. I did oblige Ms. Gaston's request. April 3rd came and went, and we did not receive any responses to the required disclosures. And when I promptly filed our motion to compel the answers. In full disclosures, we have received the required disclosures from Ms. Gaston's office, but it was after the filing and setting of this motion.
Okay.
We are asking for attorney's fees because our client has incurred additional attorney's fees in prosecuting this matter. And even though we have since received them by the date and time of this hearing, our client has still incurred the fees to deal with and prosecute this matter.
Ms. Gaston?
Thank you, Your Honor. We have made every attempt to be responsive with plaintiff's counsel and to provide expectations. I did respond to Ms. Peters' email asking about the status of those required disclosures, and we did file them as soon as we were able to get complete information from our client. We would argue that plaintiff has not been prejudiced, that we filed those effective on April 11th and provided complete responses thereto. And so we would ask on behalf of defendants that this motion be denied.
So I guess my question is why were and I know this is a new rule, so this rule came into effect after I stopped practicing and have been a judge, but so I know it takes a while for people to kind of get used to the new regime, but what caused the delay initially in getting these responses in?
So I believe that the defendants were not served until quite some time after the action was filed. And in fact, several of the parties named have not been served. So Mr. Jordan Smith and Holy Savior Hospice, I'd have to take a look at when they were served. But there was quite a delay. And then after the date of service, it took us some time to get the required information from the client. But we did file complete responses as soon as we were able to do that and had all the information, so that we didn't want to just lodge a number of objections, but actually make substantive responses.
Okay,
May I respond, Your Honor?
yeah.
I guess I'm not real clear on how service has anything to do with the due date for required disclosures. We did make several attempts to get Ms. Gaston's clients served. They were served. I don't know if there was a delay, but the rule is very clear. Required disclosures are due 30 days after the initial appearance or the filing of an answer. So service is irrelevant when it comes to the due date of required disclosures. Ms. Gaston is well aware of the date in which she files a response or an answer on behalf of her clients. That date is more clear in her mind than any of the parties. And 30 days after that filing is when your required disclosures are due. I understand this is a new rule. I mean, new is within, I think a year and a half, we've been under this rule, close to 2 years. And that's why I did reach out to Ms. Gaston. And when I did reach out to Ms. Gaston, she requested more time and I obliged the date that she requested, and then that date came and went. As far as the issue of prejudice, my client is prejudiced because she has incurred additional attorney's fees to deal with this matter. We have a client that is a single working parent, and we've got an institution and a corporation and defendants that have significantly more resources available to them to litigate matters. So our client is very much prejudiced by having to deal with these issues.
Let me kind of talk with y'all both about how I generally deal with sanctions motions. This is some of my sometimes attorneys get a little frustrated with me, but I'm not a judge who easily grants sanctions. Ms. Peters, I fully understand your position and frustration. And I guess the way I usually look at this is kind of like, I want to see, before I actually sanction somebody, I want to see a pattern that, I can understand from Ms. Gaston's standpoint how, you have a new rule, it's a little unclear, or it's not a little unclear, it's not something we're used to complying with. Before, we'd always have to get an actual request, now it's an automatic thing, how that might cause this to occur. So it could just be an honest mistake, or is this part of a pattern of something that, hopefully not see again and again. And so what I generally do is like, kind of a 2-strike rule. If they, if this is the only time this ever happens, I really don't want to sanction Ms. Gaston or her client. But if this would be kind of the first in a, feel free to bring this up in the future if something else happens where there's something that appears to be lacking in diligence, I guess. But at this point, I'm going to deny the motion for sanctions. But Ms. Gaston, I would just be on, especially high alert that you need to be careful about complying with the rules and all that kind of stuff. So we have a second motion, which is a motion to quash. Is that right?
Yes, Your Honor. Mr. Dunlap will be continued on that.
Thank you, Judge. It goes right in line with what you were just saying, Judge. The pattern that we are hoping does not get established, but what appears may have be on the way. In this instance, Your Honor, not only were the disclosures not responded to in a timely manner, but also not responded to at the time and when they were asked, when the extension was asked to be granted.
I get that.
But also, Your Honor, I I reached out and sent an email to Ms. Gaston on March 21st of this year, requesting dates for the taking of the 2 depositions. And that email went there was no response to that email. I allowed 3 weeks to pass awaiting dates from where I was soliciting the dates for so that I could notice the depositions of Kyle Smith and Jordan Smith. And after 3 weeks waiting that a response for the dates and not receiving a response to the email at all, I then selected dates that were most convenient to my client. That time, it took time and it only took maybe about 45 minutes or to an hour or so for me to prepare those notices and serve those. But then a motion to quash was then filed by Mr. Smith and Holy Savior, automatically quashing the deposition. But no dates were provided as alternative dates to take the depositions of those persons, or to even make us have some time, other dates to respond to. So what I'm, and just to be clear from a housekeeping standpoint, although Ms. Gaston's position is that only 2 of the defendants have been served, it's our position that everyone has been served with the exception of perhaps 1 of the entities. But nonetheless, we are not necessarily asking for sanctions at this time, because I agree, Judge, that doing 1 strike or maybe 2 strikes to determine whether or not this is a pattern or whether this is gamesmanship, we're not necessarily asking for sanctions in so much as we're asking for attorney's fees. And I'm distinguishing that just to say that at a minimum, our client is incurring the attorney's fees for having to prepare the depo notices, prepare the emails, requesting dates, and this work that Ms. Cantu's attorneys are having to do these really kind of fundamental things is costing her. So I'm not really looking for sanctions necessarily, but at least the attorney's fees, especially in light of the fact that these are unforced errors. And while the new disclosures rule may be new, the deposition rules are not. And requesting dates for the taking of depositions is something that's been going on since we've been taking depositions. So,
around a while. Ms.
So,
Gaston, what is your response, Ms. Gaston?
thank
Sure.
you, Judge.
I'd like to say I disagree factually with something that Mr. Dunlop stated. We did receive an email in March, mid-March, asking for dates for deposition, which I responded to and said, give me a chance to talk with Jordan and Kyle. And the very next email or communication that we got on the topic of depositions was a unilateral notice. And as I mentioned in the response, we are happy to work with opposing counsel on dates. My clients do need a bit of advance notice. They both are working and running businesses. I have talked with them. I'm prepared to offer those dates today, but I just want to be clear that we did get an email, which I responded to. We did not ignore an email. And the very next communication was a notice of depositions without any further attempt to confer about dates when both my office and our clients would be available for the depositions.
So what dates do you have available for the depositions?
Both Mr. Kyle's, Jordan and Kyle Smith, Mr. Smith, are available the week of June 12th and the week of June 19th.
Mr. Dunlop, do you have any dates during that time? That's
during either of those weeks?
Yes, Sean, we would love to take the 19th, the 20th would be my preference on those.
You wanted to take both depositions on the 20th?
Jan, I'm reluctant to schedule both on the same day because I'm not certain how long. I'd rather schedule one for the 20th and the other for the 21st.
And then, and stay, Mr. Dunlap, I would ask, the clients have asked that the depositions take place in San Antonio, because that's where they're located. Is that going to be a problem?
It wouldn't be a problem as long as they would pay for my travel to San Antonio.
Let me tell you how I usually handle that in the era of Zoom is you want to take the deposition via Zoom, Mr. Dunlap, you can. Or you can take the deposition down there unless Miss Gaston wants to volunteer. I'm not going to require her to pay for you to go down there.
I don't have that authority to agree to pay, to bear the cost of that expense.
Yes, Your Honor, and it's not that I'm trying to pick a fight. It's just that we do believe that there's going to be a lot of documents, and while Zoom depositions are done now, they're just very cumbersome when we're having to do documents.
You got two options. You take it down there and you pay your own freight, or you take a Zoom deposition. Those are got to treat you just like I treat everybody else.
Okay, fair enough. Yes, well, thank you. Then I would want to do it in person, and if I got to, I would rather do it in person in San Antonio and pass the cost on to my client than to take it by Zoom and not be able to have an effect.
Ms. Gaston, though, you're going to be required to provide a room for him to be able to take the deposition in. So
Understood.
He doesn't have to rent something that's going to be your client's responsibility, whether it's a conference room or whatever. But you guys need to be able to find some place for him to take the deposition and let him know within the next 24 hours what that is.
We can do that.
All right, so to summarize today's orders, and Ms. Peters, if you could put together an order for us, the motion to compel is moot, but the motion for sanction is denied without prejudice to raise this issue in the future, in future sanctions motion. The motion to quash, I guess, is, I don't know, denied. I'm going to, for the motion to quash, we're going to order the depositions to take place in San Antonio at a location that Ms. Gaston provides within 24 hours on June 20th and 21st. Who did you want to take the deposition of first, Mr. Dunlap?
Yes, Your Honor, I would prefer Kyle Smith first.
So Kyle Smith on the 20th and Jordan Smith on the 21st.
Yes, sir.
Okay, anything else we need to chat about, guys? Let me just check one thing about your case. I'm not sure though. Okay, yeah, you have a trial setting coming up in August. Oh, let me chat with you guys about that. So this listed as a non-jury trial. Is that going to be non-jury, or are you guys requesting a jury on that?
Well, we at this point don't have any intention of requesting a jury, but I would ask, Judge, that it be on a jury week so that if my client or any of the defendants choose to make a timely jury demand, that we don't automatically have a reset.
So this is the issue. That week, I'm only going to be able to do a one-day trial. So if this is going to be in excess of a one-day trial, whether it's jury or non-jury, we should probably move it to a different week. It's currently listed as a non-jury. So do y'all want to bump the trial, or?
I will just be very candid with you. I know for certain that this, whether it's jury or not, would be more than a one-day trial.
Okay, well, do you want to switch it to a different date?
Yes, Your Honor. Yes, if you only have one day, only room for one-day trials during that time, then
For that day, just that date. It's not like that whole month or anything. It's just
I see.
that 1 week. So if you want to do let me just check do you want to stay in August, or do you want to go to a different month? The case seems awfully new to me, but it's y'all's call. We can.
I would, Miss Gaston, again, I think as she indicated, she's of the position that only 2 of the defendants have been served. Our position is that all of them have been served except 1. You're right, Judge, it is fairly new. I would perhaps say it's something, perhaps 3 months further down the road or so.
So we could do October 24th.
Your
Yeah.
Honor, we're both in a 2-week jury trial, starting, I believe, on October 29th. I hate to cram my schedule because before jury trial starts, we
I get
would
it.
like to.
You want to do January 23rd?
That's,
Do you
I'm
have,
free. that
Judge, do you
day.
have anything in September?
September
Mhm.
of this year of 2023?
Yes, Your Honor.
September is pretty tight. On the 5th, we have 28 cases set. On the 12th, we have 21 cases set. On the 19th, we have a special setting and 15 other cases set. And on the 26th, we have that same issue with the shortened docket. So I don't know we want to do that. So September is pretty tough.
Well, January 23rd, Your Honor, as far as my calendar is concerned, is fine.
Mine as well.
Miss,
I am
Yes.
not, I have something the week of the 22nd. I could do the following week though.
January 30th. Yeah, January 30th works, or February 6th. Or
January
February 13th or February 20th.
January 30th and February 6th both work for my calendar, Judge.
Both of those work.
Mine as well.
Which one do you want?
I would probably say that January 30th, Your Honor.
All right, we're going to go ahead and reset this case to January 30th. And do you have a mediator appointed already?
No, Your Honor.
Who do y'all want to use?
Ooh, Your Honor, I would like to ask if the court had any recommendations. This is a case that involves the medical industry, if you will, hospice, healthcare organizations. If the court is aware of someone who has knowledge of this.
But it's not medical malpractice, correct?
No.
Yeah.
So one of the best medical malpractice mediators, he's kind of hard to get into, is Joel Steed. He's very well. Right now you have Andy Chatham as your current appointed. He's a former criminal judge. You can keep him if you want. If you want somebody, let's see, medical, Joel Steed is excellent, but again, expensive and hard to get into. I don't know how big this case is. And he does mostly medical malpractice, but he's very familiar with medical issues. On general commercial, of course, King Pfeiffer is really good. How big is this case? What is the amount of controversy?
Your Honor, I believe it is over 200,000. This is Ms. Gaston.
What about Ken Rubenstein? Do you guys like Ken?
I've used him before, and I like him.
Ken Rubenstein, King Pfeiffer, Jim Jordan are all good. Of course, Joel Steed is excellent, but he's again more mal and a little more expensive. On like commercial cases, Jeff Kaplan is very expensive, but very, very good. I don't know. Any of those sound good to y'all?
It sounds like Mr. Dunlap's familiar with Mr. Rubenstein, so I will defer to that.
Yeah, I don't have any objection to.
What'd you say?
I don't have any objection to Mr. Rubenstein.
Okay. Rhonda, go ahead and appoint Ken Rubenstein to this one. He does a great job. All right. Anything else we need to chat about, guys?
No, Your Honor, thank you. And I appreciate you allowing us to make the argument. Thank you, Judge.
Ms. Peters, make sure that at the beginning of the order, it says that this hearing was heard on May 22nd, 2023. If you could share the order with Ms. Gaston's and of course, Mr. Dunlap, before you submit it to the court. And can you get that order to me no later than this Thursday at 5?